Hi everyone. Thank you for tuning into our webinar on horses and the legal implications associated with riding horses on South Australian roads. Today we'll discuss horse riders' rights and responsibilities and how the Australian road rules apply to horse riders. My name is Julia Arena and I'm a solicitor in Andersons Personal Injury Team. This webinar has been created in conjunction with the firm's senior partner, Dion McCaffrey. We'll begin with some background about Andersons Solicitors. We're 100% South Australian and have been providing legal services to South Australia for over 50 years now. Our firm has 4 locations across South Australia, including our main office in the CBD, Morphett Vale, Port Adelaide and Murray Bridge. Andersons is an all-service firm practicing in personal injury law, workers' compensation, industrial and employment law, family law and wills and estate planning. We also provide services in commercial and business law and minor criminal matters. One of our areas of expertise is, of course, personal injury law. Hundreds of Australians are injured each day as a result of accidents that they often don't realise might entitle them to personal injury compensation. At Andersons, we're across all the processes and procedures required to successfully pursue a personal injury claim. We'll talk a little bit first about horses and their relation to the Australian road rules. When riders and their horses interact with other motorists on the road, their vulnerability to injury increases tenfold. Riders, unlike motorists, are unrestrained and largely unprotected, and horses, as with all animals, can often be unpredictable. Some typical incidents with horses on the road include roads with speed zones of 70 km an hour or above, outer suburbs or rural areas, a vehicle hitting the horse from behind, a vehicle failing to provide enough room and sideswiping a horse while overtaking, a horse being spooked by another vehicle or bolting, and instances where a horse has strayed from a paddock or enclosure. In my creation of this webinar, I made a point to go out and ask a number of people this exact question to gauge just how much motorists really know about horses and their place on our roads. Now, most couldn't fathom the idea that a live animal could be considered a vehicle. I received a number of perplexed looks and follow-up questions when I advised that yes, for the purpose of the Australian road rules, a vehicle includes an animal-drawn vehicle or an animal that is being ridden as a vehicle. All references to drivers under these rules include riders, and all references to driving will include riding unless specifically stated. But are horse riders subject to the same laws as drivers of motor vehicles? The answer, of course, is yes. As horses are considered vehicles, riders will be subject to the same laws as all other motorists. This includes riding on the left-hand side of the road with the flow of traffic, using clear signals by hand for horse riders, refraining from using a mobile phone while driving, and of course, refraining from riding while under the influence. Here's what you should know with regards to the use of a mobile phone while riding. If a person wishes to make or receive a call, including dialing a number, and needs to touch any part of the phone to do so, the phone must be mounted in a mounting that's commercially designed and manufactured for that purpose. If the phone is being used via a headset or earphones without touching, holding or resting the phone on one's body, then the phone may be located anywhere, including the driver's pocket or a pouch that they might be wearing. It is an offence to create, send or look at a text, video message or email on a mobile phone while riding. This does not affect the driver's freedom to hold the phone to make or receive calls or use any other function of the phone if the vehicle is parked, but not if the vehicle is stationary, in a traffic queue or at traffic lights. One of the Australian road rules we mentioned before was, of course, refraining from riding while under the influence. Now, I'm sure some of our listeners today may have come across this story that circulated in the news earlier this year. A Queensland woman was charged with allegedly riding her horse to a bottle shop while she was more than 4 times over the legal alcohol limit. The rider pleaded guilty to the charge and claimed she wasn't aware she could be charged with drink driving while riding a horse. The question then remains whether she was subject to the same penalty as any other motorist. The answer is yes. Horse riders are subject to the same penalties for road traffic offences as all other drivers. The Queensland horse rider's lack of familiarity with the road rules did not stop her from being sentenced to 18 months probation and having a conviction placed on her record. Now, despite horse riders being subject to the same road rules as other motorists, there are some Australian road rules that relate to horse riders alone. These include the fact that horse riders are permitted to ride 2 abreast with another rider, but this can be no more than 1.5 metres apart in order to allow other road users to overtake safely. Horses are permitted on footpaths and nature strips, but riders are required to give way to any pedestrians while riding on a footpath or nature strip. Whether motorists are obliged to pass horse riders at a specific distance and speed is a common question among horse riders. The answer in South Australia, however, is surprisingly no. No such road rule exists in South Australia, but you'd be forgiven for thinking that it may, because this road rule does in fact exist in Queensland. In Queensland, a motorist must give way to a restive horse. This rule obliges a motorist to pull over to the left side of the road and turn off their vehicle's engine if signalled by a rider until the horse has calmed down or travelled far enough away to not be aggravated. Though this rule does not exist in South Australia, these acts may be considered negligent driving in the circumstances, and where they result in harm may lead to a successful claim against the other motorist in negligence. So what is negligence? Effectively, negligence is the failure to take reasonable care to avoid causing injury or loss to another person. In order to be successful in a claim for negligence, a plaintiff must satisfy the following components. Firstly, the rider must prove that the motorist owed the rider a duty to take care on the roads. As a general rule, motorists and road users owe a duty to others on or near the road. Secondly, the motorist must have fallen short of the standard of reasonable care. This is referred to as a breach of the duty of care. Determining whether someone has fallen short of this standard is a question of fact. You must be able to prove that the other driver failed to take precautions that a reasonable person in their position would have taken at the time in response to a reasonably foreseeable and not insignificant risk of harm. This might include an assessment of the probability that the harm would occur if care was not taken, the likely seriousness of the harm which may result, the burden of taking precautions to avoid the risk of harm, and the usefulness of the risk-creating activity. Thirdly, the other driver's negligence must have caused you or your horse to suffer actual harm of a recognised kind which is not too remote. In order to demonstrate how negligence works, I'll now go through a short scenario of a situation that may be considered negligent driving. Joanne is riding her horse on the road in the Adelaide Hills. Peter speeds past in his car at 100 kilometres an hour and spooks the horse, who then gallops off the road. Joanne is violently thrown from her horse and left with extensive head injuries and a number of broken bones. In this instance, it is clear that Peter owed Joanne a duty of care as a motorist. It's arguable that Peter breached that duty of care, as it may be considered reasonably foreseeable that Joanne's horse would have been spooked by Peter's speeding vehicle. Further, the risk of harm to Joanne, it may be argued, was not insignificant. Joanne may have a claim for personal injury in the circumstances. She may be able to claim under the 4 heads of damages for personal injury claims. Firstly, non-economic loss, or what used to be more commonly known as pain and suffering. With regards to non-economic loss, an assessment of your injuries will be made once they have reached maximum medical improvement. That is, when you reach a point where it is unlikely you will see any further improvement in your condition. Secondly, economic loss. Economic loss can be claimed for past and for future loss. Past economic loss represents wages lost by you as a result of the injuries you sustained in the accident, while future economic loss represents your entitlement to claim for injuries that are likely to affect your future capacity to earn an income. Thirdly, medical expenses. As a general rule, insurance companies will meet the costs of medical treatment that is reasonably incurred as a result of your accident and subsequent injuries. And finally, gratuitous care. You may be able to claim for past or future care that may be provided by a spouse or nominated person under the legislation that provides personal care, home help and domestic assistance that you are unable to carry out because of your injuries. There are, of course, relevant thresholds and limits related to each of these heads of damages, however. This is, of course, a difficult question that can only really be answered on a case-by-case basis, but it is, of course, always prudent to have an insurance policy that will cover you for any damage caused by a horse, whether damage to property or personal injury. And if an accident does occur, what rights do horse riders have? In this scenario, if a rider is involved in an accident or collision that causes an injury to the rider or an injury to a horse, the rider is entitled to bring an insurance claim against the driver of the motor vehicle. For personal injuries caused to the rider can bring a claim with the motorist's Compulsory Third Party or CTP insurer. All registered motor vehicles in South Australia are automatically allocated a CTP insurer, which will cover motorists from claims for compensation for injuries or deaths arising out of the use of the motor vehicle where the driver was negligent. The negligent driver will also be responsible for the injuries or death of a horse. If the driver is comprehensively insured, this would cover the loss. If the driver does not have comprehensive insurance, the loss will be payable by the driver. That does bring us to the end of our presentation today. We hope we've covered any questions or concerns you may have about riding horses on South Australian roads and the legal implications that come along with it. If you have any further questions, please feel free to send us an email at marketing@andersons.com.au or call through to our offices on 8238 6666. You can also connect with us on social media via our Facebook page, Andersons Solicitors, or our online blog, which can be accessed through the Andersons website at www.andersons.com.au. Thank you.